Diseño y marca.
Design and brand. The power, the synergy that empowers entrepreneurial value. Robert Katz, partner of Robert and Witcoff, of Banner and Witcoff, United States. Edanela Perez, senior IP counsel, Philips, Netherlands. Luiza Duarte, partner of Murta, Goyanes, Brazil. Moderator, Iván Sempere, co-CEO, founding partner and director of the legal area of PADIMA, Spain.
Okay.
Okay. Okay, it's just a time apparently. Okay.
So, thank you, ASIPI, for the invitation, and thank you, Edanela, Luiza, and Rob, for speaking today here in this beautiful city of Panama and this amazing conference celebrating ASIPI 60th anniversary. Congratulations, President of ASIPI, Luis, and all ASIPI team. Just to give a little bit of context in relation with the topic of this session, you will agree, hopefully, that the term brand is a broad concept, including not only trademarks, but also the perception consumers have of a company and their customer experience. But it's truly difficult. It's truly difficult to build a brand reputation without a proper IP protection strategy. In fact, winning an exclusive right in relation with a distinctive sign or in relation with the aspect of a product or its packaging is somehow protecting or taking care about the message a company wants to put in the market. A company wants to locate on or target minds. Therefore, for protecting brand identity and values, both designs and trademarks are key tools. And both designs and trademarks must be coherent in time and must have a purpose. Tesla aims to be the automotive revolution thanks to or because of its futuristic designs, and also, for example, Patagonia brand. Patagonia designs are simple, functional, and sustainable because of those are the brand values. So, this is the scenario we have in this session, and you are the actors. You are the actors, and what we expect is you to share some thoughts about the interplay between designs and brands or trademarks for increasing the brand value of a company. You, the audience, can read the profiles of our guest speakers in LinkedIn, but let me or allow me to say just a few about each of them. Luiza Duarte is partner in Murta, Goyanes, Brazil, and she's got an LLM IP law from George Washington University, by the way, that Rob is teaching there, the George Washington University. She has license to practice both in Brazil and New York. And today, she's speaking on behalf of Havaianas. Rob is partner and shareholder of Banner & Whitford, one of the US leading IP firms. Rob was a former US PTO examiner and is one of the best practitioners in relation with design matters I know around the globe, representing top global brands. And Edanela Perez Broce. She was IP counsel in Adidas and Tommy Hilfiger, and now she is senior IP counsel at Philips International, responsible for trademarks and design global protection at growing beauty and medical products. She loves cooking. So, Edanela, let's see if we can cook a nice panel, okay? Design innovation is at the heart of Philips. And we all identify Philips brands with innovative products. So how do you build this holistic IP strategy at Philips? The floor is yours. Thank you.
Hello, everyone. Thank you, ASIPI, for inviting me on this 60-year anniversary. I'm very happy to speak here in Panama, my home country, and also share a bit of what Philips is and what we do. I will tell you a little bit of Philips, what we sell, what is Philips today, but I will also tell you a little bit of our brands and how we do our protection of our rights to enforce them. Let me start with our purpose. So it is our purpose at Philips to improve people's health and well-being through meaningful innovation. Philips is an innovative company, and we aim to improve this life of 2.5 billion people by 2030. And we do this with sustainability in mind and with innovation in our heart. So Philips is an innovator. Philips has been around for more than 130 years. He started with breaking innovation. I can show you here, it started with entrepreneur. We expand beyond lighting, and after the Second World War, got a global expansion, and then it diversified in the industrial conglomerate and start focusing their portfolios according to different businesses. Philips is based in Eindhoven since 1891, and is a company that has definitely shaped itself in many different ways. You know, products go and technologies change, but Philips has the value to maintain a very strategic way of looking at the marketplace, and is still there, is still standing. And the most important, continues to create meaningful innovation to improve the life of people. So here I choose a couple of very interesting patented inventions that create Philips through the years. Here, for example, you can see in 1939, the introduction of rotary shavers. I mentioned this one because we're going to talk about them today. It's one of our most successful consumer-facing products at the moment. I mean, but after that, you can see all these, like the TVs, you can see in the medical area, you can see, for example, magnetic resonance, and in the latest years, like more products and software in relation to medical health, helping hospitals and helping care for our patients. So Philips has become in the last decennia really a hard medical company. And we do this business in a very responsible, sustainable way. I think it's important for me to mention today that we have a sustainable strategy composed of 3 pillars: environment, social, and governance. You can read more about this in our websites and our annual report. But here I put some of the important comments that we have on these 3 pillars. So I mean, we know Philips of many, many brands. We have many different ages here. If I dare to ask for which products you know Philips today, I don't know if some of you feel answering that question. Yeah. Electronic toothbrush, very good. Anyone else? You have a pink one, fantastic. That is very good one. Haven't. I mean, any other one? Like iconic product or Shares, yeah, right. So you all kind of very update. No one mentions TVs, and that's interesting because we do license our brand nowadays, and we have 3 major licenses, and these are really traditional Philips products. So many of the older generation will recognize and will say Philips is a TV brand maybe, or they will say it is definitely a light brand, or will say it is domestic appliance, and then the air fryer and so on. These 3 group of products are Philips, but they are now brand licensees. So we have a portfolio that is more big than this, but these are the 3 most important ones because these companies nowadays are enormous and they do their own brand protection, but we do make sure that the quality is still under Philips standards. But let's talk about Philips today. Royal Philips has 3 main businesses: diagnosis and treatment, and here you can read what means that, connected care, and then patient care, workflow management. These are really hospital-related businesses. And then the one that I'm gonna talk to you today is the business of personal health. And then you will see there that includes oral health care, mother and child, grooming and beauty, which were the businesses that some of you mentioned today. And I also add this slide because then you can see that only 20% of our business relates to these consumer-facing products. The rest of the products are obviously consumer-facing, but probably patient safety, patient-facing. So I hope that you don't need to face those, only if you are in a hospital, of course, and if you are, I hope you are being treated with Philips because innovation and quality will be on a superior level. So this personal health business, what makes is make sure that we create personalized solutions to make your day-to-day easier and happier, and that you have a healthier life. And so these are the products. Let me go a little bit faster so that we have enough time. So you see here Sonicare, our main trademark, Sonicare for these kind of products. You see here Avent, main trademark Avent. All of you that are parents will be very familiar with this brand. So our portfolio, Philips brand, still in the top 100 of all brands, according to Interbrand. We have go a little bit steps down. Well, there are some litigation that have taken a lot of the attention, but it's still quite strong with more than 11 billion of net sales. And our IP portfolio. We have a quite enormous portfolio. It's not only comprised of trademarks and designs, but it is also patents, our domain names. It's quite a big portfolio, and it's quite relevant and is in use. Our priorities, of course, we make our main filings in Europe, US, and China, and we do also in relevant countries around the globe, and that will depend on the needs that we have to enforce or the need that we have for the business. So to the subject that I'm supposed to talk about, so the creation and the protection and our clearing process. I cannot talk about creating without telling you what I do as an in-house counsel. So this is a process that starts with our research and development team. I am in constant communication with them. I try to understand what they are creating. What they are creating is novel, if it's original, can be patented or not, and then we help our researchers and our designers to understand what they are creating and how we can translate that for an IP right. That is in a very early stage of the process, you know, and we look into every possibility of obtaining an IP right because that will give value to the product that we are creating, and also to be able to map what are the inventions that are connected to a certain product, and also what are the designs and trademarks that we can create. And in this process, we influence our designers, our marketeers, to make choices that will help us to protect these products. So here is the most innovative shaver. I hope some of you have this product at home. As you can see, this is branded with the Philips. We have covered as a trademark also what we call the shape of the panel. But you also see our technologies trademarks, Skin IQ, our logo for Skin IQ. An interesting trademark that I have protected is this little design here on the head of the shaver. And this helped me to stop a big problem that I confronted when I joined Philips, the copy of the replacements of these head shavers. So we thought, okay, we should protect that so that we can make sure that we take these replacements out of market. And we have done that. I'll show you a little bit more about it. So here are some of the trademarks that we have obtained to solve that problem, and also some that were created already in the clearance process. So you can create a portfolio of trademarks or designs during the design process, but you also sometimes need to create new rights to defend a product after creation, because at that point, maybe you didn't know that will be an element that you will need to protect. And we have created as well design rights. And these design rights allows you to protect the shape of your product. And here I just include a few examples, but this shaver will have many variations of the designs, including fissures, taking away certain elements to make sure that we have a very flexible design right to use against a bad actor. Another important element I want to show that has proved to be quite efficient is that we try to do also features of a design, then we will claim the light. This product can tell you, with this ring in the handle, whether you are pressuring too hard or too low, and it allows you to have that information, and therefore there is a communication with the user, and then how we protect that. So we protect it to design rights, and we have been able to enforce it. And then there is the user interference, so how we protect that communication. So we have done design rights around these icons, around this user interface, and with the new regulation in Europe, we will be able to improve improve this kind of protection. So Sonicare, again, we have the trademark Sonicare, we have Philips, we have the shape, we can enforce with those, but then we noticed that there was, again, a sort of user interface on the handle, and we wanted to protect that and that communication and that interaction, so we did design rights for that. But we also noticed that there were some copies in the market, and I'll show you later. So we create the Wave trademark, and that trademark has helped us to stop copies of our packaging. One blade, and this is my last, so I still have a bit of minutes. So one blade. When I joined Philips, I noticed that one blade is a very special product. It was created in 2015, has an enormous, strong design protection, because at this time, it was the first one blade, you can say, or the first electric shaver that had one blade. And the shape was really special, so we have very strong design rights. And this is since 2015. Also, very interesting about this product is that this product has patents, a number of patents on it. For example, the connector, so how we connect the handle to the blade. So it is a very valuable product, and we should be able to stop, for example, replacements of this blade, because this blade is protected by design. So if you want to make a replacement, you need to make sure you have your own connector that doesn't stop, that is not infringing our patent, and in addition to that, you need to make sure that you create your own design. So we identify a lot of bad actors that were copying the lime green color, for example. So we started a trade dress case in the US, and we won it, so we got recognized our trade dress color for this product. We also decide to do 3D trademarks for the shape, and the reason for that is that eventually our design rights will expire. You know that in certain jurisdictions we will have Instead of 25 years, we will have 10, 15, and therefore it's important to have a strategy after the expiration of our rights. So therefore, 3D trademarks in certain jurisdictions has proved to be really helpful. And the same with the panel. So I had to file for the panel with Philips, with one blade, to make sure that people will not copy our packaging. So this has been a product where we have created a lot of new IP after the creation of the product, after 10 years, where we sometimes can claim secondary meaning for the word one blade. So we continue to be busy because we know that this product is not to go yet, and that we need to make sure that there is relevant litigation that will help this product to keep bad actors away. So some examples, so these were the products that we were able to stop through our trademarks. This is an example of a light ring shaver that was copying our design, right? This is an example of head shavers using our deco cap, this small design that we create on the head shaver. This is a copy of our one blade trademark. They use our one blade wordmark on their product. This is an example of replacements that were copying our lime green color, and we are able to stop them. And these are all examples of different shapes of one blade that we've been able to stop in the market. So some recommendations, I do believe that it's not only about trademarks and design, but about an IP strategy and holistic IP strategy for the protection of a product. So I like to look at the product and then decide how we're gonna defend it. It will guarantee the success of the product in the market if we have good IP protection. It will definitely increase the value of the product, and usually when we are analyzing litigation, we need to create a business case, and we need to include whether this product is valuable in terms of the trademarks, the IP assets around it, and that will give more value to the product, so I'm allowed to do more litigation. And of course, this will facilitate combat against counterfeits and infringers. So as an in-house, I think it's very important to communicate and influence the creation process of IP rights. Sometimes I feel I'm also a designer, or I'm also creating trademarks. I do it together with our designers. I give them advice to improve certain products, to make it more novel, to make it more distinctive. And this will allow us to have this portfolio of products and of trademarks and IP assets. And we should train our colleagues, we should train the authorities to understand what are our programs about and what is what we are protecting. And as a third one, I always invite brands to enforce their rights, because only by enforcing we know the extent of our IP rights and how strong they are. So, as a conclusion, a good combination of design and trademarks rights will help to keep exclusivity and will keep bad actors from your market space. Thank you very much.
Thank you. Thank you, Edanela. Thank you for your recommendations, and also for bringing concepts like communication, enforcement, education as part of the innovation process. Thank you so much. Rob, we will have the time to elaborate a little bit more after in the questions space we'll have it at the end. Rob, you represent many different brands in many different jurisdictions. You are in a privileged position for sharing some thoughts about how do you manage the interplay between designs, trademarks, etc. So please, the floor is yours. Thank you.
Thanks, everybody. As Iván said, we are blessed in being able to represent a number of design-driven clients, and we get to see stuff across different industries. And you will see a lot of overlap with what they do at Philips, because they obviously are good at what they do, and you'll see a lot of shared strategies. So when we get to certain aspects in some of these slides, I'm going to go over some of the overlap parts a little bit quicker. But there's a lot of aspects that go into forming a brand. Obviously, the history of the reputation, the quality of the goods, all sorts of stuff, reliability, basically everything that interplays with reputation all focuses on brand. This presentation's really focusing on the product details and different aspects of it. We see across the globe really a lot of people that are good in one part or have some knowledge in one aspect of IP law and not others, and it is important to have a holistic across-the-board protection. As IP attorneys, if we're outside counsel working with in-house counsel, there's only a few opportunities or a few aspects with things that are related to branding that we can get in at with respect to product details. Obviously, if it's a utilitarian invention and you're doing a patent, then you're working on that little piece. But if it's the appearance of a product, there's only a small section of what we can do that impacts the brand. The brand's going to be driven by the way it's advertised, what the public thinks of it, all sorts of stuff. And the goal of getting all these IP rights is to enforce and establish marketplace exclusivity, right? Because if you're the only person in the marketplace that has a product that looks like this, people are going to see it, they're going to appreciate it, and the people that like it are going to go to it and go to it over and over again. So in most jurisdictions, certainly in the US, and that's what my presentation is going to be focusing on, in order to get rights, they have to fall into a particular bucket. So when a new product comes or we're asked to consider it, you have to consider all those forms of IP every time. Can't overlook any of them. And while they're separate buckets, they all overlap, right? And some of them don't work well together, and most of them work well together. The big area where they don't work well together is usually utility patents and trademark and trade dress. But most areas can work well together if you're smart about it from the aspects. I would say design patents work really well with all those forms of IP. And so that's going to be where we start with our advice on here. But again, don't overlook potential of the analysis for copyrights or even utility patents. So with respect to the US and design patent tips, I'm going to say be a know-it-all, right? You can't be a dabbler and just get a design and file it and move on and thinking you've got meaningful design rights. There's all sorts of things. Really, it's a big, at least with respect to US law, it's really about portion practice is really important. You have to know what to claim, what to disclaim. You have to have good instincts. So there's an aspect of art and practice in addition to the law. There's a lot of pitfalls that exist in there, so you have to get the basics right in addition to the cutting edge stuff right. You're going to need to have multiple applications if you want to really thoroughly protect a product. We've got the ability to have a special statement that works with the drawings to get protection in different angles. You can use symbols and figures and shading to represent different aspects. You can have an appendix which will let you amend in different ways. You can rely on the appendix to file continuations and divisionals. There's all sorts of flexibility that you have in the US that I think people from outside the US frequently overlook because they're just filing what they filed in a different country 6 months prior. But again, next level protection is really important, and I know we try to be as creative as the designers when it comes to how to protect it. So a couple of examples here, right? So this is a LeBron shoe we did for Nike. You know, there's a lot, we filed a number of applications on this, but we knew the one salient feature that jumps out was that triad-shaped raised element on the side. So in addition to everything else on the shoe and all the different aspects that were unique and creative, we filed on that, and as you can imagine, bunch of people in the marketplace knocked it off, and we had a really nice, perfect design right to enforce. So that's one thing, but you break that down, that shoe is creative enough we could have filed a dozen design patents on that. I don't remember the exact number, but obviously on important products for any client, you want to make sure that you're thoroughly protecting it. You can protect contrasts that's many designs that's important, and it's a generic contrast, right? So what we did in this particular case, this was a cooler by Yeti. There are certain aspects. So the top stripe, bottom stripe, there's a middle stripe where the zipper is. There was a different contrasting color where everywhere where it's heavy stippled was one color, and everywhere where it was light stippled was another color. And that formed the basis that really is almost a trademark-like that we see with some of these contrasts. So we could we could do the contrast and stippling and say in our special statement that the contrast and shading represents a contrast and appearance only and doesn't represent any particular color, material, texture, or finish. So any contrast, bam, that's all right. This was another interesting one we had. This was from a jeweler. A new idea she had was to have a pendant, and then she had rings and other jewelry products that had a certain look under one lighting condition, and then under a UV light, a part of those stones lit up a different color. So we filed 2 states, and in the second state, we said the stippling shown on the stone region in figure 8 represents a contrast of appearance with respect to the remaining stones, and the change of state is affected when the pendant is exposed to ultraviolet light. That almost feels like it's a utility patent, right? But that's the kind of stuff you could get cutting-edge protection with designs. You can use symbols. This is one we did for a Vapor Max midsole, and you can see it's a rainbow. And so without getting pinned down to exactly where the colors change, or whether it was a slow color change or an abrupt change, we basically use 6 symbols spaced across, and we use symbols, and we say that they symbolically represent the colors. So again, and I think when you get the good design patent rights, it helps everything. It helps enforcement. It helps get potential trademark rights down the road, and it is the cornerstone of protecting products. To get trademarks, besides it extending the term, it's a different right. So the proofs are different, the defenses are different, where you might enforce it are different. In the US, we have different laws for every circuit for trademark laws, so, and the remedies are different. So being able to have those flexibilities is nice, but you probably don't want to seek trademark rights if your product, if it's a stopgap product that you're only going to have on the market for a year, you're probably not going to want to do it, because 2 of the main proofs you have to be entitled to it is you have to prove acquired distinctiveness or secondary meaning, and then it also has to be non-functional, and that is a much tougher bar than you think it is, and basically anything that contributes to a functional or marketplace benefit, there's a good chance that's going to be fought over as to whether it is non-functional. But keep those 2 points in mind, and those examples on the right are just product configuration marks, as you can imagine. But those 2 points we talked about, I wanted to make sure that this tip gets conveyed to everybody here. Almost every company of a large enough size has an advertising department and marketing department, and they like to tout all this functionality. And advertising can have a positive effect on trademark rights and a negative effect. So I'll start with the positive effect. And the positive effect is you could help with acquired distinctiveness. You can use look for advertising. Look for the widget with the curly Q in the back. And if you're the first one with a widget with a curly Q in the back, and your advertisements and your commercials and your printed materials all say look for that, and you're focusing on that, it's going to help get your acquired distinctiveness. So it's nice when you're considering these holistic approaches that you're strategically considering whether this is something you want to seek long-term trademark rights on, and get the marketing team involved. But the same thing too, you have to get the marketing people involved because they like to tout every functional benefit of each product. And so really, if they start touting a couple of them or just one that could be enough to kill trademark rights potentially. And I use this example on the right. It's a Samuel Adams. They designed this special mug. It's supposed to make the beer taste better. And you can see, or it's lager glass, but you can see the five different arrows, 6 different arrows there. And every arrow on that glass points to an alleged functional benefit. The laser etching on the bottom, creates bubbles for, basically every aspect of that glass, they push a functionality to it. So there's not a chance in the world they're going to effectively be able to procure and successfully enforce a trade dress rights on that product configuration because of all of that. But sometimes you're willing, if you holistically think of it, that approach may be better than seeking trademark rights, but everyone needs to think about it and get on board. If you can categorize what you're trying to protect as product packaging, and if it's inherently distinctive, so super creative and different from what's been done before in that area, you can get trademark rights on that, but for that trade dress. But you have to be able to categorize it as trade dress, and then if you get inherent distinctiveness, you do not have to prove acquired distinctiveness. Copyright tips. A lot of people overlook copyright tips for product configuration. The first one we see up there is one of the famous ones that we teach at George Washington University. But if the product is not part of a useful article, and that's a toy, right? It's not a useful article under the definitions of U.S. law because it doesn't fly, right? It's a kid just uses his imagination, his or her imagination for that. So that is copyrightable, protected just like that. But if it is a useful article, you can get protection, copyright protection on that work if you can imagine that work separate from the utilitarian aspects of the article. And you see two examples here. You've got, these are little, it's string lights, but they kind of have a balloon covering effect, and that got copyright protection there. And then you see these rainbow clips there that they got protection on that. You can imagine that bird clip separate and apart from the functionality of the clip. Here's one for a bathing suit. They were able to get protection on that. They were copyrightable because the decorative black trim and T-shape are physically separable and demonstrable works of art. So every product that comes in the door, if you're doing a complete analysis, look at the copyright too. Get copyright protection. That's a really nice approach. And then for copyrights, if it's created in the U.S. or if the creator is U.S. based, or if the creation is first published in the U.S., then you're going to want to file a copyright application in the U.S. because first of all, you do have to have a copyright registration in order to enforce it, and if you're doing online enforcement, that's going to be helpful. And then also you want to do it because it provides you statutory benefits. Here's one, copyrightability of a shoe. This is a Yeezy shoe that Adidas got a copyright protection on. The Copyright Board of Appeal said the works contain a sufficient amount of original and creative 2 and 3D dimensional authorship for registration based on the low standard for copyrightability. So don't overlook copyright, consider them with the other rights. And I'm going to finish up here with utility patent tips. Everyone thinks of utility patents as this functionally works better, let's get utility patent protection, but you can use utility patents to protect the appearance of products. We've done it many times before. We teach in my class how to do it. It does work at odds with trademark rights, so if you're going to file a trademark, you need to make a decision early whether you want to go the utility patent route or the trademark route. But once you make a decision, you need to go all in. This is one example I use. I think it's easy for everybody to understand. Goodyear got a utility patent And the claim was a tire comprising a first background pattern formed by linear ridges and interrupted by smooth surface patterns, creating an irregular mosaic pattern on the annual exterior sidewall surface. So basically, design patents will protect that actual appearance and things that have similar appearances to it. Here, you have protection on that if you have an irregular mosaic pattern. So that creates that product. And then here's another one as an example. But I've got dozens of these examples. But a golf ball. So they wanted to protect a golf ball, kind of the stars and stripes, to simulate a flag. But instead of filing just a design patent, they got utility patent protection here, presumably in addition. But basically, you have a first hemisphere with at least 40 dimples, having stellated polygon, basically star-shaped dimples, and the second one having at least 5 grooves with no dimples. So no matter, there's an infinite number of ways you can do it, and a utility patent can protect those in addition to the specific design. So again, as we talked with Phillips, don't overlook other aspects. Anything that the user or customer interacts with should be considered. Graphical user interface, icons, fonts, anything. And then takeaways, we don't have time for takeaways, but I'm happy to talk about takeaways with anybody else after the session's over. So thank you all very much.
Thank you. Thank you so much, Rob. Well, I think we share same fundamentals, same principles, but the approach are different in many, many aspects. So it's crucial to share underlying strategies before filing, before drawing the strategy, thinking globally. Maybe we have a little bit of time after Luiza's presentation to elaborate a little bit more about this. Luiza, Havaianas is top brand, shaping nice looking designs with flip-flops, but the trademark embraces many other different categories of products. What are your thoughts in relation with Havaianas' strategies for protecting its IP? Thank you.
Sure.
Go.
Hello. Well, thank you, Iván, for the warm introduction. I'm very happy to be here today to talk about 3 things that I'm passionate about: design, branding, and of course, Havaianas. For those who do not know me, I've been working with Alpargatas, the owner of the Havaianas brand, for more than 20 years, assisting in enforcement actions, IP prosecution, but also legal advice in general. And from the very start, I was fascinated by Havaianas. Here it was a simple product, a rubber flip-flop that managed to consistently outshine its competitors over the years. So this is a good opportunity to show how Havaianas can exemplify the power of synergy between design and branding to actually create business value. So let's start from the beginning. Havaianas did not invent the wheel, nor the flip-flops. The product was actually inspired by a traditional Japanese sandal, which had a distinctive rice straw soles. And Havaianas, Alpargatas honored this inspiration and added to its sandals little oval shapes like grains of rice. And this was not only a nod to its inspiration, but an early indicator, actually, of the brand's thoughtful approach to design, even in early days. The name Havaianas was also carefully chosen. it is supposed to evoke the sunny, vibrant Hawaiian way of life. So it translates these values of the brand and also simplicity. So Havaianas, even in the beginning, started not only to present itself as a new product, but also as an idea, a story itself. And in addition to that, the company was also concerned with innovation. So in 1966, it actually got the first patent for the first rubber flip-flop. And so for many years, Havaianas stuck to a basic formula. It had a white insoles with colored straps. It was only blue and black in the early days, and the outer sole matching the same color. And it was a product designed for construction workers and laborers. And so it was actually a utilitarian product, durable and affordable. The first change actually occurred by accident. Due to production error, some sandals were produced with different colors. And instead of discarding these products, Alpargatas decided to put them on the market. And they were a huge success. People loved it. They were instantly sold out. And then Alpargatas acknowledged this success, the customer's demands, and added new colors to its line. Then the second transformation came in the 90s, thanks to surfers, who would then flip the insole of the sandals to make monochromatic products. Alpargatas also noticed this trend and then started making monochromatic sandals. So one thing that is crucial for Alpargatas and actually justifies or explains part of its success is that it is always listening to consumers. By incorporating customers' preferences into its designs, Alpargatas actually created a sense of connection. People felt like they were part of the brand story. They were co-creators. And I think that this particular issue, together with, of course, the Brazilian flag that was later on added to the sandal, is the main reason for having a product that causes much affection, especially by Brazilian consumers. It's a product that people are proud to be wearing. But it was only in 1999 that Alpargatas reached the high-end fashion. It was when the sandals walked on the Jean-Paul Gaultier's runway show that Alpargatas had actually the opportunity to grow outside Brazil. And at that time, Alpargatas then created different models, different shapes, different colors, different patterns, and then could be seen as a product of style. And what is remarkable is that even after reaching such fame and being considered a fashion icon, Alpargatas still preserved 4 key elements. So since 1962, all sandals have the Havaianas name, the Greek logo, the Greek pattern in the stripes, the rice pattern in the insoles, and an ellipse, elliptical logo, which is either in the middle or on the bottom of the insole. But all these 4 elements are crucial for Alpargatas' success. They are not merely decorative, they're not merely ornamental, they have no functional purpose. They're actually the core of the brand identities, sorry. So in terms of brand strategy, protecting these elements, specifically the rice pattern and the Greek pattern, was not an easy task, and it's not today. So many trademark offices dismissed applications for these marks based on saying they were decorative or functional and never distinctive. So to tackle this situation, Alpargatas got creative. The legal team and the commercial team got together and decided to create a strategy to expand the use of these elements into additional products. So they started putting the rice pattern in towels, the Greek pattern in luggages, in purses, in the side of sunglasses, all of this to create the sense that they served as brand identifiers. So this consistent use actually helped in not only IP prosecution, helping us show to the trademark offices that these elements were really distinctive and served a trademark function, and were not only ornamental, and also in disputes as well. In terms of design protection strategy, Alpargatas International Company, it is aware of its international responsibility and liability, and therefore it conducts prior art searches, or better, freedom to operate searches to confirm that it's not infringing third parties' rights. Unfortunately, cannot seek design protection for any and all product. Because of budget constraints and the various models they launch per year. So what they focus on is to protect the iconic shapes, and they are intended to last, not merely seasonal trends, and also in strategic markets and key jurisdictions. And as many brands, some of the most usual challenges that they have is because while operating in so many countries, they have to abide to so many different legal regimes and different problems. So, for example, in some countries, Alpargatas' biggest concern is with counterfeits, like Brazil and Latin America. In other countries, the biggest concern involves parallel imports, like Australia and Europe. And in others, like US, for example, regulatory issues. So, in addition to these different problems, they have to be created and adapt to construe a customized IP strategy for each country. So, for example, in some countries, inherent distinctiveness may be a problem to get protection over the rice and Greek patterns. In other countries, we may find an alternative form of protection by means of position marks or secondary meaning marks when they are available. But what is important is to always keep a close interaction with the commercial team, listening to consumers, and try to find a way out, even if it comes from creative alternatives like the one that they devised when they decided to expand the product line, adding these distinctive elements to reinforce the identity of their brand. Of course, language barriers is also a concern. Havaiana is not easily pronunciated in many countries. Alpargatas means a type of shoe in Portuguese and also Spanish. So, and also we have the problem of different alphabets, having to translate the phonetic of certain words to different ideograms, to Chinese ideograms, for example. This is also a hurdle, having to align with the commercial team to make the same, to protect the word that they are using in sight. And budget constraint is always a hurdle. It's always a problem, I think, to any company. So the idea here is to prioritize what we can protect and think about always of cost-effective measures, like instead of filing oppositions everywhere, maybe sending a warning letter, or better, an email trying to reach an amicable solution, either changing the mark or making a request or requesting limitations of the description of goods, and these types of things. So what I would like to say here, I think the conclusion would be that it is important to understand how the synergy of design and branding can really create business value. And I think that Alpargatas is a great case study, especially because for us, IP attorneys or practitioners, because it shows that with effective IP strategies paired with strong design and branding, we can transform the simplest product into a global powerhouse. So thank you very much for keeping with me. Thank you. I'll be happy to hear questions.
Thank you. Thank you so much, Luiza. And I think that Goyanes is a great example of how some partial designs became trademarks and are crucial for global IP protection. So thank you so much for sharing those thoughts. Any questions from the audience? No. Where? Oh, okay, good. Thank you.
Thank you so much for a wonderful presentation. I really enjoyed it. I have two main questions. Probably one is probably outside the scope of the trademark design. One is probably for some of you, the three speakers, what elements you take into consideration to choose a design or a tridimensional trademark? This is one. And the second one, probably for Philco and Goyanes, how do you include the issue of the domain names conflict in this strategy to prevent the use of the trademarks?
So I think I didn't get the second one.
Yeah.
Could you repeat the
Yes.
second one, please?
The second one means if you include in your strategy of protection of trademarks the use of domain names to prevent the illegal use of the trademark as part of the domain name.
Okay, so first question is dealing with the choice in relation with designs and 3 trademarks, and second one is dealing with, okay, you got it, no? Okay, good.
I can do the first one. So I think you don't need to technically choose. I think you need to make sure that you have 2 options. And I think it will depend on which countries you're working on, because there are countries where design rights are difficult to enforce, whereby a 3D trademark will be easily to get protection from and also easily to enforce. So I think the first thing you need to know is, okay, for which countries this product is relevant, for which country this product might have some issues, and do we have to have a right in that country? And then we will decide whether we do a design right or whether we do a 3D trademark. And then, so it depends on the jurisdiction whether it is better for you to have a 3D or a design right. Now, for design rights, we do have deadlines to meet, right? So what I do personally is that I have a portfolio of countries where I want to have the design right in place because I know I will probably use it eventually. So design rights do have a deadline. We don't have that problem with trademarks. So we can always later on file for a 3D trademark, like the example I showed with one blade. So it's a strategy after product is already launched. Well, designs always require a strategy before launching. So who wants to answer the second one?
Actually, could I just supplement your answer?
Sure.
So the first thing is I think you shouldn't necessarily think, do I want to go trademark or design patent? The fact is they're complementary rights, and that you can't get trademark rights, at least in the US, on product configurations unless you have acquired distinctiveness. Well, you don't get acquired distinctiveness until the public associates that particular mark with you, and that's really hard, and that, you know, millions of dollars of sales, millions of dollars of marketing, lots of units sold. So you know, in almost every situation, you're going to want to start with design rights and use those design rights to get your exclusivity. And then once you have your exclusivity, if there is a need or a benefit for getting trademark rights thereafter, well, then your design rights help you get to that step. But you shouldn't think, do I want design or trademark? I think it's always designed to protect, assuming you have novelty on the design side, and then use that to get your trademark.
Okay, thank you, Rob. Anything to add? Do you want to add anything?
The second question?
In relation with domain names. Okay, just before that, I just want to add a little, if I may. Okay, and also the content of the rights is different. So we also should think about how we are going to be copied, because it's not the same content, a design right, a trademark right, or a copyright. The content is different, so the enforcement is also different. So depending on the jurisdiction and the strategy, we might choose one thing or the other. And now, domain names.
I didn't understand the question on domain
Second
names.
one was relationship between trademarks and domain names, and if you consider domain names as part of the strategy of IP protection. Is that right?
Yeah.
Yep.
Thank you for your question. Yes, definitely. We do protect domain names all over the world as well, especially against cyber squatters and even from unfair competition. So we do have a broad strategy of registration of domain names and UDRP proceedings, different top-level domain names.
That's right. So, any other questions? I think we are running out of time, because if I'm not wrong, at 5:30 we have another event here, which is los premios de diseño, ¿no? ¿Es correcto?
The design prizes, is that correct? The design awards, is that correct? Okay.
Okay, so here we can read 13 minutes, but we have no time. So this is not true, okay? So let me switch into Spanish just to say thank you all for speaking in this panel. Muchísimas gracias una vez.
Thank you once again to ASIPI for the invitation, and now I ask the audience to please stay here for a minute, because now we're going to give the design awards, and if we do not award and promote the creativity in design, it will be harder for us to protect later. So let's stay here for this important initiative, not only from ASIPI but also from the design committee. That's it, and thank you very much.